Are you struggling to pass the CPA exam? Did your review course fail to fit your learning style? I'm Darius Clark of I-75 CPA Review, the #1 course supplement, where the right teacher makes all the difference. Most business law topics don't change or need to be updated very often. Questions about contracts and who bears the risk of loss during shipping, those questions haven't changed in 50 years. And that's because most business law topics don't contain dollar limits. It's not like individual income tax questions where there's a standard deduction and every year it goes up a little bit. Or there's limits about how much you can put into your IRA and every couple of years it goes up a little. Bankruptcy is one of those very few business law topics that do change and need to be updated every few years. And that's because bankruptcy has some dollar limits, and whenever you have dollar limits, you have what's called cost of living adjustments. And the last cost of living adjustment for bankruptcy was back in 2019, so guess what 2022 is? 2022 is a cost of living adjustment year for certain bankruptcy topics. So if you're trying to use old business law material to study bankruptcy, don't do that. Now the CPA exam begins testing these bankruptcy changes in October of 2022, and this YouTube video will cover the most likely 2022 bankruptcy topic to be tested that features a cost of living adjustment. And that topic is involuntary bankruptcy. With involuntary bankruptcy, you have the creditors forcing the debtor into bankruptcy. The debtor still is in denial and not ready for rehabilitation, but the creditors are tired of the debtor's delays and excuses. The creditors just want to get paid, and they know by forcing the debtor into bankruptcy, they're going to get a lot less than what they're owed, but they'll take something rather than nothing. If the creditors can establish that the debtor belongs in bankruptcy, it becomes a numbers game. The number of unsecured creditors required to file, 3, if 12 or more unsecured creditors exist. Only 1 unsecured creditor is needed if there are fewer than 12 unsecured creditors. Notice what word keeps repeating, unsecured creditor. Why? Because only the unsecured creditor is relevant when trying to force the debtor into involuntary bankruptcy. Secured creditors, if you see that in the question, ignore them because they don't count when trying to force the debtor into bankruptcy. Only the unsecured creditors count. Why is that? Because the unsecured creditors, they have the most to lose if the debtor never pays. The secured creditor, if they don't get paid, they could foreclose on the debtor's warehouse, they could repossess the debtor's inventory, they'll get something. But what about these unsecured creditors? They don't have anything to show for their debt. They're the ones who have the most to lose. They get to force the debtor into involuntary bankruptcy. And it's always best to understand why. So now that we know that only the unsecured creditor matters in an involuntary case, let's play the numbers game. The number of unsecured creditors required to file, we said, are 3 if there happen to be 12 or more unsecured creditors. But only 1 unsecured creditor is needed if there are fewer than 12. Now, we said it's a numbers game, so we continue with how much has to be owed to these unsecured creditors in order for the court to recognize the fact that the debtor belongs in bankruptcy. And the answer is $18,600. And that means the group of unsecured creditors who are willing to file, they must be owed at least $18,600. They must be able to show the bankruptcy court that they're owed $18,600 or more, and that these debts that add up to at least $18,600 have become due and the debtor hasn't paid them. And that's how an involuntary bankruptcy petition starts. The creditors file against the debtor. And if the petition is not contested by the debtor, the bankruptcy process will start as long as the amount owed is that $18,600. And as long as you have the right number of creditors filing the petition, and as long as they can establish that these debts have become due and they haven't been paid. And that leads us to a very important term, the term known as equitable insolvency. See, because creditors must prove grounds. They must prove that the debtor has not been paying debts as they become due. That term is known as equitable insolvency, and that's what acts as evidence that the debtor is behind and belongs in bankruptcy. Because the debtor could have debts of $18,600 or way more than that, but as long as they're paying everybody as the debts become due, then there's no problem. But the real trigger of involuntary bankruptcy is the fact that the debts have become due and the debtor's not paying them. If the creditors can establish equitable insolvency, they can usually force the debtor into bankruptcy as long as the amounts are owed and you have the right number of creditors filing the petition. Now, creditors must file in good faith. If creditors file a bankruptcy petition against the debtor in bad faith and the debtor successfully contests the petition, the debtor can collect damages from the creditors, including even punitive damages. All right, let's try this question because on the exam they could ask you something like this. Your client has 15 unsecured creditors and owes each one $7,000. Assume your client has not paid anyone for 5 months. What do we call that? That's evidence of being equitably insolvent. Haven't paid the debts as they become due, 5 months behind. How many unsecured creditors are required to file an involuntary bankruptcy petition against your client? So to play the numbers game, if there's 12 or more creditors, you need at least 3 who are owed $18,600 or more in order to agree to file the petition. So here we have 15 creditors, which is clearly more than 12. So you're going to need at least 3 creditors. But you might need 4. Because if you can't add up to $18,600 with just the first 3 creditors, then you're going to need a 4th one. It says that each one is owed $7,000. So if you grab 3 creditors, you're up to $21,000. So 3 creditors would be enough here. Let's go with C. C is correct because creditors who wish to file and can prove they haven't been paid when due, they need to establish unsecured debts of at least $18,600 in order to file involuntarily against the debtor. Since there are 12 or more creditors, at least 3 have to agree to file against the debtor, and those 3 have to be owed at least $18,600. Now, we always try to anticipate the next question, right? That's the I-75 difference. What if there were less than 12 creditors? Then the rule is any one can file as long as they're owed $18,600. But could one creditor file if there was only, let's say, 10 creditors here? No. Because the first creditor would only be owed $7,000. You would need a second one to bring you to $14,000, and that wouldn't even be enough because 2 creditors would only combine for $14,000. So you would still need a 3rd creditor even if there was less than 12 creditors here because you've got to establish that the unsecured debts are at least $18,600. All right, let's try this. Your client has 8 unsecured creditors and owes each one $20,000. Assume your client has not paid anyone for 5 months, so there's evidence of equitable insolvency right there. How many creditors are required to file an involuntary bankruptcy petition against your client? And the answer is D, 1, because creditors who wish to file and can prove they haven't been paid when due need to establish unsecured debts of at least $18,600 in order to file involuntarily against the debtor. Since there are less than 12 creditors, any one creditor who is owed more than $18,600 may file a loan, provided they can prove equitable insolvency, which it says they haven't been paid in 5 months. So notice how each one's owed $20,000. So any one creditor can step up and file against the debtor for involuntary bankruptcy. Because according to the facts of this question, each unsecured creditor is owed $20,000, and $20,000 is enough to file on your own. You don't need any help from any other creditor. And since there's less than 12 creditors, any one creditor can file on their own. So let's review the numbers game. The number of unsecured creditors required to file is 3 if there's 12 or more creditors, but only 1 is needed if there's fewer than 12 creditors. And remember, only the unsecured creditors are relevant. Let's try this one. Your client has 5 unsecured creditors and 10 fully secured creditors and owes each one $20,000. Assume your client has not paid anyone for 5 months. So there's 15 total creditors, 5 unsecured, 10 fully secured. Everyone's owed $20,000. No one's been paid for 5 months. How many creditors are required to file an involuntary bankruptcy petition against your client? And if you think you know, leave me the answer in the comments section. And don't forget to like and subscribe because it helps the channel out a lot. And if you need more help with business law or any part of the CPA REG exam, go to cpaexamtutoring.com with me, Darius Clark, where the right teacher makes all the difference. Get on I-75 and be home soon.